Item 1 for motion.
May I please? What's it? I have challenged the order 9/1/2019, madam. Page 79. May I read? It's written statement, my
Statement is
lord.
in which page?
Page number 10, my lord. Written statement is 2, dear. One additional statement also, dear. Written statement, page number 10 and additional 17.
Which is the best document to connect you to your projected parents?
My lord, my father has come here before 1958, my lord. My father had a land, my lord, in the year of 1955 and 56. So that is the annexure 3, page number 28, my lord.
28.
Yes, my lord. My father's name is Mir Ali, and he has a land, my lord, in the year of 1955 and 56, my lord. Look, dear, my lord,
Produced does not have any what do you call it? It doesn't have any remark. This is
my lord, annexure 3, my lord, page 28. Jobanbandi.
this is in Assamese Purna Exona Jamabandi.
Yes, my lord.
Annual.
Annual, my lord.
Did the land revenue officials come and depose in your favor?
My lord, revenue, we shall not come. But I have a land along with my brother, my lord. I have two brothers. Along with both, we have a land, my lord. That is the page 34 and 37, my lord. Jabanbandi copy, my lord. 34 and 37, my lord. Thirty-four. My elder brother's name is Meser Ali, and second brother's name is Raiba Ali.
I don't think this is an exhibited document.
Yes, my lord, that is the exhibited documents, my lord.
This is exhibit number.
Exhibit number 2 and 4, my lord. And first one, my lord, exhibit 3, my lord. My father's land. My record was also called for, my lord. Record here, the record is here, my LCR is here. Father's name is Mihir Ali, my. Mir Ali, my.
Counsel for the petitioner and Spencer for the respondents. by filing this writ petition in Article 226 of the Constitution of India, page 79, opinion dated 9/1/2019, passed by so and so and so and so. Declaring the petition to be a foreigner post 25/3/1971 stream. As the record of the tribunal is received, issue rule returnable forthwith without requiring any press steps to be taken. For the FT matters, considering the projection made in the writ petition, then it's time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Gaurang Mahodaya. Lists the matter for hearing in the week commencing 1/12/2025.
My lord, my intemporary is considered. My intemporary is considered. When bail period is
Granted you bail.
massive.
Item 2 for motion.
Yeah, Lord. Lord, is a contested matter, my lord. Imperial order plus 83, my lord.
Page
83, my lord. And earlier, my lord, she has also approached Bishop of this honorable court, my lord. And the honorable court remanded back earlier order, my lord. Thereafter, second order has been passed. Plus 83, my lord.
2018.
No, my lord. 2021.
Which
I-
page?
Page 83, my lord.
82.
83, my lord.
3.
Earlier, he has approached my lord challenging the 2018 orders, my lord. The Honorable High Court, my lord, remanded the same, my lord. And thereafter, this order has been passed. But in this order, my lord, nothing has been
What is
mentioned.
the explanation for delay?
This paragraph 26, my lord.
26.
26, yes, sir. He's 70 years old, my lord. Old lady. Page 27, my lord. About 81. 76.
But you have no documents to connect you to your projected parents.
School certificate, yeah, ma'am.
School certificate.
Lot.
Which page?
Page 66, my lord.
This is exhibit number,
Ag-
exhibit 3.
Agreed, 3. One is Gavura certificate, two is consent certificate.
But this exhibit 3 is contains state emblem. It can't
Lordship, that
the
is why my-
contents.
all the certificate has a state emblem is there, my lord.
But then you have no connection. Once this document goes, you have no connection at all.
Jamabandi copy also there, my lord, but the same is name has not been Uh, it is mentioned the father's name Alta instead of Akhtar.
Which is that document?
Jamabandi, my lord, page 68, my lord. Her father name is Akhtar, but here is written as Altaf.
This is exhibit number?
Exhibit 6. Is exhibit 6.
One, two, three, four, five. 6 is Jamabandi.
Lordship.
Mr. E. Mubarak, and counsel for the petitioner, and so and so for the respondents. Page 83. Opinion dated 26/8/2021, passed by so and so and so and so. Next, in view of the inordinate delay in asserting the opinion dated 26/8/2021, comma, keeping the issue of maintainability open, comma, issue notice returnable on so and so. Give date after 4 weeks. Extra copies within 2 days. Call for the relevant records from the consent tribunal. Following email address of the said learned tribunal. The prayer for bail shall be considered on receipt of records. Next, in the meanwhile, if the petitioner, namely so and so, is apprehended, comma, she shall not be deported out of the country without order of the court.
Masla.
Item 3.
May I please election. There's impugn order, your worship, on page 67.
So, but Mr. S. Islam, the counsel for the petitioner, and so for the respondents. Opinion dated 12/12/2024, page 67. Dated 12/12/2024, passed by so and so and so and so. Notice returnable in 4 weeks. Call for the relevant records from the consent tribunal. Extra copies within 2 days. The prayer for bail is opposed by the understanding causes for the FD matters. Considering the projection made in the writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Dhubri. List after police on receipt of records.
Obliged.
Police.
Upgraded item 35 for orders.
My lord, I've prayed for accommodation. Actually, my file is misplaced, my lord. So, my lord, may I on 31st, my lord, due to shifting chamber, my lord. There is delay, my lord. Delay is there, my lord. So they file objection also, my lord. Maybe they are not present to them. 31st, my lord. 31st July, October, my lord.
31st July.
October, sorry. Sorry.
Okay, inform the other side.
Yes, my lord. Actually, by order, they bring this matter, my lord, but they are not present, my lord.
No, because you can't then upgrade and take it up. Wait for your turn.
My lord, on 31st, because my,
No,
my,
they have
my-
brought it by order. Then we can't adjourn it like that by upgrading it.
my file is misplaced, my lord. So I-
It's okay. You renew the prayer when the matter is called in usual turn. Take it up then. Because if it is by orders, then it will be
Yes, my lord.
wrong
So,
to
so I have to
withdraw it.
mention this.
Upgraded item 36.
Lordship, may pass out for the time being, Senior Lex on another court, Lordship.
Yes, 37.
Item 37.
My lordship 36, 37, 38, 39, my lord. All are brother and sister. Same family, my lord. And they are belongs to, my lord, Assamese Muslim community, my lord, Tengaghat, Dibrugarh, my lord. And they are behind bar, my lord. This case, my lord,
Maintainability because you are challenging the opinion of 2021.
Yeah.
What is the ground of delay in making the challenge?
yes, my lord.
Because you did not come to tribunal to prove the documents.
Yes, my lord.
I think WS was filed and thereafter evidence was not led.
Thirty-six Shopikul Ali. Serial. তিনটা কথা একটা মিস্টেক আছে
Hola, soy el Kiki. No, ese Kiki. No, es Kiki.
ওরে তুই হেরি একটা কথা আমি আমি অলরেডি অ্যাপ্লাই করছি হাতে বানানো হবে হ্যাঁ আমি ঠিক করে দিলাম Seven. Okay. Miller. Miller, in this case, Miller, after expiry order, Miller, petitioner file the miscase for Miller, setting aside expiry order along with condonation, Miller. That is also rejected, Miller. And
But you see, order 9/13 does not apply
Yes.
in a tribunal proceeding. So Sharma, it was you have you annexed the order 9/13 petition here?
Miller,
Have you annexed it?
yes, Miller.
Page
Case 25.
25.
25 and 29, Miller. 29, Miller.
So Sharma, just go through this.
29,
29.
yes.
এই pending আছে। এর নাম কি হবে? Please keep item 38 and 39. The only thing we see is that the opinion was passed during peak COVID period. Hmm?
Review order was short from 2020. After that, it's not immediately will be.
So Ahmed, we don't find anything to interfere. Except that the opinion was passed during COVID period. But in your order 9-13, this that was otherwise not maintainable. We don't think that the order is wrong.
No, sir, I am not on Miller. It's behind bar mill. They are belongs to indigenous Muslim community mill, Assamese Muslim community mill. There and there happens from Tengaghat, Dibrugarh mill. And
But the fact remains that the after filing of the written statement, it was not contested.
yes, Miller. In the expert order, Miller, the expert order passed on the verbal submission of the learned government advocate Miller, which is reflected in the order Miller.
Yes, because there was no appearance.
Miller petitioner behind bar Miller, they may be allowed to go on bail Miller.
No, but if on merit there is nothing,
Yes,
how can you omit that?
on my humanity ground Miller. They are
Hmm?
the and they are actually they are the original Miller indigenous Muslim community Miller. And they are not the other Miller, Purva Bungia Miller, other Miller.
But you see, we'll have to first find out what is wrong in the order. And this is a very badly conducted case for the
Yes, Miller.
tribunal.
Yes, Miller.
But we can't do anything.
And this case, Miller, the case is not conducted properly, Miller. And also
but we
not
can't do
cited
anything.
properly, Miller. They're the Mason Miller, they're the
But
driver
we
of
can't do
tempo.
anything about it. The
They does not move, my lord. What is the procedure, my lord, actually? And now they are realized.
But you're
Now
not
they are
finding
realized.
any material
One
to
chance may
interfere.
be given, my lord, to substantiate to prove their case. My lord.
We are really not finding anything to interfere.
All are same family member, my lord.
Hmm?
All are same family member. My lord. Three brothers, one sister, my lord.
So we understand, but we don't find anything. Unless you give us any material for on which we would interfere. We find it very difficult.
And during the lockdown period, my lord, actually.
So we understand, but
All
look at the
separate.
petitions. Lockdown is so underplayed that it can't be a ground even for interference.
Entire family in the detention center. my lord.
Mr. Ahmed, you'll have to give us some handle. You take it up on Monday. You find it out. Because we are not getting anything.
Yes.
All sides are represented on the prayer made by Mr. A.M. Ahmed and counsel for the petitioner. List on 27/10/2025. Find out some answer
All
because
these four items, Lord.
Hmm?
Four
All these four
all
items.
these four items. You know, there was there's again a disconnect because that's why we saw all the records.
Yes.
In one of the case, Rafiqul, this case was transferred from one tribunal to another. And on transfer, this notice was given. And without knowing anything, the lawyer drafted a petition saying that Rafiqul notice was issued not to us.
I have
Therefore,
seen the
we-
record, my lord.
Therefore, all these four records we
Yes,
had to
the
read.
case is not conducted properly, my lord.
But still, is a learned lawyer, we can't do
I'm,
anything.
I'm not giving blame to the lawyer, my lord, but
With a learned counsel, we can't do anything. We can't
Uh-huh.
even touch. We can make a statement against him. Very badly conducted case.
complex.
You see, this, we always say that these charter accountants, every year they will have to study. They earn points in attending conferences, they earn points in attending classes. And that is how the next year their licenses are renewed. There's nothing of that sort in the lawyers. And therefore, this is what is happening. 80% of the foreigners' cases get bad because of
Yes, my lord.
the manner in which cases are conducted.
Conduct is very poor, my lord.
But everybody is very
And-
happy.
And in the my lord, Upper Assam, my lord, there is a lack of.
No, we
foreigners.
don't know.
That's why, my
We
lord,
don't know about.
and there-
I do. We have both of us. We don't have any personal knowledge. But everybody is happy with that.
so many cases is registered in the Lower Assam, my lord. That's why, my lord, here in my lord, our learned council is going for the operation.
Upgraded item 42 for orders.
Regular course will call.
Item 4,
You've seen the records.
May I please, your lordship?
Lord,
You've seen the record?
It was earlier heard, Lordship, I think,
No,
Lordship,
heard and
and
allowed,
order, yes,
Yes.
Lord,
heard and allowed.
yes, Lordship.
Lordship, if there is a note, Lordship can go with the same.
Because
I will not want to jail, but
No, you have two notes.
Mhm.
You have like. the
Yeah, that's right.
citation.
because here also it is same, the exhibits are not, they are not discussed.
Yes.
On that ground only we send it. What's your name?
D Gonmai.
D.
Gonmai.
Gonmai.
Rongmai.
Gonmai.
How do I spell it?
Gonmei.
Gonmai. Okay. You have any objection if you allow it? No. That Ms. Chi Rongmai, Learned Counsel, appearing on behalf of Mr. Adhar, Learned Counsel for the petitioner. Also heard so and so for the respondents. Next para. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner, namely so and so, has assailed the page 29 opinion dated 30/12/2016, passed by so and so in so and so, thereby declaring that the petitioner is a foreigner and not a citizen of India. Next para, in view of the order which is proposed to be passed, comma, the court does not find any requirement of referring to the pleadings and evidence on record. As it is seen that apart from referring to the exhibit number 1 to 5, 1 Roman 1 to Roman 5, comma, none of the said documents have been discussed in the impugn opinion. Full stop. Accordingly, the court is inclined to extract the contents of the opinion dated 30/12/2016, herein below, page 2930. Huh? Next para. It is noticed from the hearing before quoted opinion that the petitioner has referred to the contents of exhibit 1 which is the voters list of 1966 containing the name of the projected grandfather of the petitioner. Full stop. Moreover, Exhibit 2 is Roman 2. Exhibit 2 is stated to be the school certificate of the father of the petitioner, which according to the petitioner has linked the petitioner to his projected grandfather. Stop. However, in the absence of any discussion on the said exhibits, the court is of the considered opinion that the matter is required to be remanded back to the learned member of a foreigners tribunal fifth Silchar for passing a fresh opinion after discussing the exhibits on record. Next part. In the opinion of the court, as the issue of the as the foreigners tribunals deal with the issue of citizenship of the person against whom proceedings have been drawn up, it is incumbent on part of the learned tribunal to discuss the evidence and then pass an pass an opinion. Next para, resultantly, the court is of the considered opinion that the said impugn opinion being devoid of any discussion on the exhibits is is not sustainable. So accordingly, the said opinion dated 30/12/2016 is hereby set aside. Next, the matter is remanded back to the learned member, foreigners tribunal fifth, Silchar, for passing a fresh opinion after examining all the exhibits, examining and discussing all the exhibits. Next panel. The petitioner is duly represented by his learned counsel, who is directed to appear before the said learned tribunal within the outer time limit of 24/11/2025, and by producing a certified copy of the order, await for further orders of the instructions from the said learned tribunal. Next para, in the event the petitioner does not appear on the date fixed, it would be open to the said learned tribunal to treat the petitioner as absent on call and pass a fresh opinion in accordance with law. Next para, the registry shall send back the records of the tribunal expeditiously. Along with a copy of the order to be made a part of record by the learned tribunal. Last date of appearance is 24/11. Make sure that the petitioner appears on that day before the tribunal. Representation stands allowed to the extent as indicated above.
Item 6.
May I please, your lordships? This case, I think there is a written argument also there. Earlier, it was so many judgments also produced. I think it's available there. Right? Earlier to heard before Honorable Mr. Justice M.R. Patak, lordships. And impugn order is that lordship. Opinion is page 54, lordship.
54.
54. And here I found lordship only statement made, lordship, there is no consideration at all against the exhibited document.
Your,
What are documents that have been stated, but no consideration at all?
no, how do you link with your projected
Link
parents and grandparents?
My lord, annex exhibit A, B, C. Exhibit A is the NRC of my father, and exhibit B is NRC of my mother. Exhibit B. Exhibit C is the voter list of my uncle Ismail Sheikh. Exhibit D is another NRC draft.
Which page is that NRC of
NRC
exhibit
lordship
A and B?
land-
Where are those?
Lordship, first kindly see lordship and exhibit C lordship 1966,
Page?
exhibit C page 30. Page 30.
13,
30
30.
lordship. My uncle's name here appeared lordship Ismail Sheikh. And Mojanessa is my aunt lordship. Uncle Ismail Sheikh's wife lordship. And to link lordship exhibit E, that is page 20. Draft Sita, where my father's name, uncle's name appeared, that is of the year 1958-65.
What, how do you
Exhibits-
link?
link
Was your
Yes.
uncle examined? As
Uncle
witness?
examined, Gaubura examined lordship. And I also adduced evidence, the documents is exhibit E is the lordship, Sita lordship, page 20.
Exhibit E.
Exhibit E, page 20. Link with my father lordships. Ismail lordship will find Ismail Sheikh Hikmat. Hikmat is my father, and Ramjan Sheikh is my grandfather. Here, lordship finds certified to be the draft sheet of land dark number so and so for the period 1958-65 under Titapani Moja village Borbita.
Which page is exhibit E?
That page lordship exhibit type copy lordship Barnicula page 20. And page 21 is the Barnicular lordships. And my name appeared along with the father lordship, that is Bhuta list 1985 lordships.
No, something is wrong. The documents do not match. E. Say. A2, 81. Your documents do not match.
Not matching lordship.
Mr. Sharma, you and Mr. Barmia, please look into it. I flagged the document. This doesn't match with page 21. This page 54 the Dag number, the Pata number is 400. In your page 221, the Dag number, the Dag number is 381. 341, huh? Three bigger, two gutta, 6 lechas. It's not the same land. At page 21.
Lordship, we verify, Lordship. All Lordship may take up day after tomorrow and then I'll verify at my.
No, I verified, that's why I have given it to you.
That's a, Lordship may take up day after tomorrow also. Comparing my. our
Not day after,
read
Monday.
list. Yeah. Monday. My land friend said Monday, Lordship. Oh, Monday, Lordship.
It's,
Lordship.
and I am nobody's friend.
No, he said Monday.
It's okay.
I have not followed, Lordship. Sorry.
Both sides are duly represented from the clear mid time, which I active for me and based on 27, 10, 23.
Obliged.
Upgraded item 35.
They bring this by order, my lord. They bring this method by order, my lord, and there is delay to 229 days, my lord. My file is misplaced, my lord, only one day for day accommodations.
Like that, in the month of April 2050. And they intentionally.
Well, Monday, my lord. Monday, on 27, 27, I'm out of station, my lord. My 31st, my lord, October, my lord, up to 30, my lord. My lord, here, what happened, my lord, initially they filed a repetition, my lord. And that was, my lord, there is order, my lord, their termination was not set aside. Subsequently, again, they filed repetition, my lord. And
No, whatever.
yes, my lord, yes, yes, my lord. Only 8 days, my lord. Yes, only 8 days, my lord.
Petitioner has a right to
Yes,
object.
yes, my lord.
Even there is no power to delay.
No, it's okay, but today he doesn't have a file. He says it's missing. Take it up on 31st. No adjournment on.
Yes, my lord. Yes.
Both
Because
sides
I'm-
are presented. Prayer for adjournment made by Mr. S. K. Medil and transfer for the
Appellant.
applicant
Okay.
is strongly opposed by by Mr. A.K. Khanna and transfer for the respondent. Private respondent. Prayer for adjournment is allowed. List on 31/10/2025 is made clear that no prayer for adjournment
Yeah, I'll done.
on that date.
Yes, my lord.
Item 7.
Lordship? Yes, Lordship, I was appointed as a Amicus Curie. On last occasion, the engaged counsel appeared before honorable court, Lordship. He appeared. So they again, external.
Appears on call for the petitioner. However, all the respondents are represented. Next para. In this case, due to continuous absence of the learned counsel for the petitioner, this court had appointed Ms. T. Begum, learned counsel, as amicus curiae. Full stop. However, when the matter was taken up on 30/11/2023, the learned counsel for the petitioner appeared before this court, and accordingly, by the said order dated 30/11/2023, this court had relieved the learned amicus curiae while appreciating her service in assisting the court on the last two dates. Next para. Today, when the matter was called, the learned counsel for the petitioner has remained absent. First of, however, notwithstanding that the learned amicus curiae was relieved by order dated 30/11/2023, she is in showing her sincerity in the matter, has again appeared before the court. First of, we once again appreciate the gesture of the learned amicus curiae in appearing before this court. And is in the court. Next para. While once again recording appreciation towards the learned amicus curiae, as there is a judicial order dated passed on 30/11/2023, relieving her in view of appearance by the learned counsel for the petitioner, her further presence is no more required in the matter. Next para. We made it clear that the matter is being adjourned for range of justice. First of, if the learned counsel for the petitioner remains absent on the next date of listing, adverse orders would follow. So in the earlier paragraph, where I said she's not required, there you add the registry shall strike out the name of the learned amicus curiae while listing the matter next. We put on record our appreciation towards your appearance, but see, there is a judicial order. We go by that. But we really thank you for being here.
I'm blessed, Lordship. Lordship, my name is, name may not
Uh,
appear.
we have ordered that.
I'm blessed.
We really appreciate your sincerity in appearing.
Yes. Thank you.
Item 8.
Petitioner, how are all the respondents are represented? Next, for ensure justice, the matter stand adjourned today. So it is made clear that if the petitioner remains absent on the, unrepresented when the matter is next called, adverse orders would follow. Next, list on 31/10/2025.
Item 9.
May I please, Lordship? Lordship, matter may be adjourned for the day, Lordship.
Just now. Both judges presented on the prayer made by learned counsel to petitioner, the matter stand adjourned today. Next, this being a old pending matter, list again on 31/10/22, right? Before, let me say that it's made clear that as this is old pending matter, the matter would not be adjourned on the next date of listing. Next, list on 31/10/2025. No adjournment on next date.
Item 10.
There's no representation from the petitioner. However, all the respondents are presented. For ensure justice, the matter being adjourned today. First, it is made clear that if petitioner remains absent on the next date of listing, my adverse orders would follow. List on 31/10/2025. So that's at it. We said in the last order we said this being an old pending matter. That-
Item 11.
That's it, guys. That's right. May I please, Your Lordship?
Lordship, this is not the matter, very old matter. I understand now that in the year 1916, this case was actually came to me and all these things from the tribunal, Morigaon. The notices received by my client, along with the other members of the family. But during that, after that notice, they isolated me, and the family members were not actually tagged with me. And I became the petitioner subsequently before this honorable tribunal, assailing the tribunal's order. This tribunal's order in there, 16, no? Yeah. Page 74. Page 74. Yeah, that order contained that I belong to a foreigner in between 1966 to 71. So according to the foreigner's expulsion, this 10 years, he is to remain here without having the franchise, as not as a citizen, but after 10 years, he will be allowed to. So that point actually hurt me. While I am not a foreigner, I am born and brought up in India and that place, and this chief maker did this harm against me. So he invoked the jurisdiction of this Honorable High Court by a writ petition. So that petition contained about my all these all these documents like that of my recognition as a local person and all that. So he took time to collect all these things. But as an ordinary village man, it is always difficult for the person to collect voter list and all this sort of thing, Tabula certificate and this and that. So everybody in one word that said that since family members are not actually tagged with you, they are remaining as such, and you are isolated as a person in between 1966 to 70. That's actually 10 years, you will not be allowed to vote, and this way you will remain. And after 10 years, you will be naturalized by what you are to report in the police register, your name should be there registered. So that actually hurt me that I am not actually foreigner.
Mr. Uda, did you get yourself registered?
Pardon?
Did the petitioner get himself
No,
registered?
no. Without getting registered, I actually invoked the jurisdiction of the Honorable High Court. That why should I be actually indicted in such a manner? I am not actual 66 and 67. I cannot reconcile all these things, but I am not a foreigner. My family members are not a foreigner, but this has been done without actually proven all such things. So I came to challenging this. The Honorable Tribunal actually, Honorable Tribunal, when actually viewed that 6670, I came to the Honorable High Court. Honorable High Court petition 38. Page 38. The Honorable High Court, this petition came before the Honorable High Court, and Honorable High Court was pleased to actually to pass a separate order by way of saying that.
So this is a previous ex parte opinion,
Yes.
which was set aside and you are permitted to contest, and therefore you have contested and this page 74 has come. Your earlier-
Not expired. Lord.
Your earlier order appears to be at page 19.
Page 19.
I may be wrong, but since I was reading without any assistance, this page 19, the documents were there, but the tribunal rejected it on the ground that it was not duly proved, and therefore this was set aside. This is 2016 to 2016. This is the order.
At the tribunal level, it page 19, as Lordship has rightly pointed out, that an advocate of that.
No, you were there. You contested the matter. Your evidence is there.
Yes,
right?
contested.
Contested, yes.
This
But
actually
this order was set aside
set aside.
by page 38.
Yes. Page 38.
Yes, and
Yes.
this
30,
page 38
39.
order, page 38 order is reflected in page 75. Third paragraph,
70.
being agreed by judgment and order so and so, WPC 5539.
Yes,
This is referred to.
yes.
Because now now your documents were rejected. Basically, this the exhibit A, that is Gambura certificates, were disbelieved because that was during the continuation of proceedings. Same ground, exhibit G was rejected. Moreover, it contains state emblem. So these two documents, the court disbelieved these two documents, and thereafter there's no connect between you and your projected parents.
Lordship, actually, I am trying to inform the Lordship. Here, the case is
Because this time now, you have been declared as a
Okay.
foreigner post 25 in 1971.
yes, 1990. I've never that so, but this has been made out here. In sense, actually, I am not actually an illegal entrant. I am a regular person here, a citizen. My legal plea, his grandfather, father, and all the elders, they have their voter list, they have land property, they have all that shifted one place to another sometimes because of the river and Brahmaputra areas are full of actually erosion and all that. Some things happened in the past. But it's difficult to collect the records, the papers which are not available in circle office nowadays at that moment also. But even then, despite of all this, I could collect all things. What this learned tribunal actually did, they did not actually help me by way of exhibiting, to exhibit these things. There was ignorance actually, there was apathy from the side of it. So my learned advocate, whom I engaged, I am not I'm an illiterate man, but I actually engaged a legal advocate. He has done something in a way, the WS he has submitted, where particulars were in short, not it complete. Halfway particulars were recorded there.
Before you came, in fact, we had discussed this matter, not your case, but the
So after the Lordship, this
but the lawyers who are dealing with the foreigners matters in the tribunals. But we can't do anything. Your written statement says nothing. It does not even disclose the name of your grandfather. And you wanted to link yourself to the grandfather, and that link was missing because there was no name of the grandfather on record. That reading is not there. Because you see, you had a good document. You are exhibiting exhibit F, which is a Jamabandi of 1931. It contains the name of your grandfather, but you couldn't connect with your grandfather because readings are not there.
this has not been actually, I could not actually exhibit these things, but they don't, without exhibition of papers, all papers have been on record, they have collected, they have actually mentioned here also. There are some papers which has not been executed, exhibited, but that's all on record. The other matters, after 2 or 3 persons examine, that is actually another way. another papers that were given, submitted to the tribunal at the, from the petitioner, that is on record, that is, but CPC says that you cannot actually keep things like this. Either you accept or reject. These documents were there in a something else, yeah? And the Civil Code of Civil Procedure to 1908, there actually page 108, I would say I am reading out and then Lordship will be supplied Lordship. Documents not admitted in evidence shall not form part of the record and shall be returned to the persons respectively producing them. It is 7, recording of admitted and return of rejected documents. Rejected documents, why it is actually in the record?
Oh, there are reasons for that. Let me tell you, Mr. Uda,
No, sir.
I'm saying this with some experience in the trial court. You see, what happens is that those documents are there and those are taken up and kept in part D file. And therefore, this part D file by default remains there. These are not returned. This is by habit because none of the judicial officers, they take the trouble of taking these documents and returning it to the parties. And therefore, this is at least since I joined, long back in 1992. Since then, I have never seen any judicial officer returning the document. And we hardly see even the lawyers wanting the return of the documents. But therefore, by default, what we have learned is to omit file D when it comes to civil records. We don't take cognizance of the documents which are there in the D file. And incidentally, the civil court rules and orders which you are referring to, that does not apply in the foreigners tribunal cases. So therefore, under the foreigners tribunal's order, 1964, there is no provision of return of the documents. And merely because the document is there does not cause you any prejudice. It's not your case that because the other documents were there, I could not argue my case properly.
That is actually not the way, actually, whole things I am resting on that. My humble submission, never would be before your lordship, that let this matter at least go back again so that he can actually place all the stories which is on record with the cogent evidence, and that will be a form of actual reply to this actually foreigners issue.
But how do you, even for that,
At least non-exhibited record, which are on record, non-exhibited documents which are on record, that may be exhibited before that tribunal,
but that's
and
not
that
your-
opportunity will help me.
That's not your projected case, Mr. Da.
No, sir.
You see, if any document were there, you see, you have seen the evidence of the witnesses. The oral evidence was read before the tribunal. Apart from this affidavit, I don't know for what reason, but oh, achha, now I get it. Earlier the oral evidence was taken, and thereafter the evidence on affidavit was filed on 13/6/2018. Is the deposition annexed in your writ petition? Is the evidence available in the writ
41.
petition?
41, huh?
Is it there, Mr. Sharma?
Page
Yes, page 41.
41, yes.
Now look at this. Contents proves nothing.
Lordship, 41. Lordship, time is over. Lordship, may I obstructing a court time
Pardon me?
because of this court is to rise that I'm just taking your Lordship to be.
Mr. Huda, when you are there, we can bend
No,
time.
that of course. Deposition of OP number 1, Rahimuddin, so and so, in the form of affidavit in connection with the above cited case. MD Rahimuddin, aged about so and so, Saitullah, son of Saitullah, so and Balidunga, Buragaon, in the district of Morigaon, Assam. I am a permanent resident of the above address and a citizen of India by birth. This is true. That I have been born and brought up at the above cited address. Even my father and grandfather also born and brought up in this address up to their death. The 42, Lordship.
You
that-
may not spend time in reading it, but just see exhibit, sorry, paragraph 3, 4, 5. It doesn't say anything. Nothing is proved. Look at the manner in which evidence is led.
42, that I have all the relevant documents of Indian citizenship, voter list, land, records, etc., and all other relevant documents in our names. That opposite party, so-and-so, son, so-and-so is my wife, and so-and-so are children. That we all the opposites have all the relevant documents to prove our Indian citizen. Some documents have been submitted as exhibited so-and-so. Kambura certificate, Gram Panchayat certificate, voter list of 14, the voter list of 1970. The question raises that you are, and your voter list you are showing, there your age was 34. Why not the earlier voter list you have not submitted? So
No,
this,
but here also it doesn't write anything. Gambura certificate, it's just like saying,
yes,
you have seen those arguments. I'm just reminding you. The AR 1927, please read AR 1927. You'll get the case there. If that is a submission made. How will I understand AR 27 PC without giving a page? How will I understand what document is being referred to? You have seen those arguments in court.
there are documents like that of say Gambura certificate, the Panchayat certificate.
Gambura certificate is what?
Yes.
Doesn't say anything. No, neither the contents are referred to.
Yes. Voter list of 1970 in the name of father of the opposite party. Voter list of 96. I am concerned that before 70. Before 70, if my father's voter list is there, in that significant, the father's name is actually in the voter list of 96. If voter list of some other subsequent period, and
But
if
you
that
see-
continues,
You see, the problem is, come to page 44. There starts your problem. In cross-examination, you say,
yes,
I don't know the date of my birth. I do not know the age of my father as recorded in voter list of 1966. I do not remember the year of death of my father. He expired 5 years ago. There's a case pending against my uncle in foreigners tribunal. One of my paternal uncle has been declared to be a foreigner by foreigners tribunal.
Lordship, that actually answer in respect of all these answers. Date of birth for some unsubstantiated class of people. Who remember about his date of birth? An
I don't
unsophisticated
know.
class.
I can tell you right now my date of birth of my grandfather.
It's difficult.
No, I would remember it. So therefore, I can't
That-
imagine
that-
somebody
you are
not
right.
remembering it.
If I have that culture for anything, I do it, then I remember it. But here is this unsophisticated class of people, cultivation, also he is busy with other matters. but he used to remember the date of birth of his father, mother. How many of us actually we remember the date of our father and date of our mother? Date of our date also, even I remember date.
I'm speaking for myself. I can't speak for others. I don't know whether others would remember it or not.
That's
So far as I am concerned, I would know the name of the date of birth of my grandfather.
I do not know the age of my father as recorded in the voter list of 1966. I do not remember the date of my father. He expired about 5 years ago. There is a case pending against my uncle in the foreigners tribunal. One of my paternal uncle has declared a foreigner by the foreigners tribunal. So somebody was after them, some did it, but Gahmura is the real person who is to be examined, whether he knows he's a government Gahmura, whether other voter list 11-2 prior to 1970. He speaks about their name, relationships, father, parents are there, legal tree, from which legal tree they have actually come up. So if they can actually produce this, one document is actually genuine proof. Page 78, 78 a paragraph, kindly Lordship may produce.
Yes.
78 to 3 paragraphs below. During the continuation of the proceedings, the proceeding on 12/7/18, a list of documents which have been produced. The documents enclosed with the list, certified copies of voter list 75, voter list 85, voter list 97, 205, 2010, 2018, and one copy of NRC details and certified copy of Jamabandi. But the said documents have not been asked to as exhibit by proceeding, and the documents have not been endorsed by me, as the documents have not been marked as exhibit and have not been endorsed by me, the aforesaid documents cannot be accepted. So this is where my difficulties are there, on whose fault actually it has happened. That is another aspect of things. I have come to the highest court. Lordship will consider this aspect. I am a poor man. I may be given the chance to produce this, exhibit this through the causal evidence to save me from this actually difficulties that I have been confronting with Lordship. This will help me a lot. This is the highest court, fair justice. I will receive justice from this one. And that is my humble prayer before the Lordship.
Take a short break and come back.
That's it.
Lordship, can I answer?
That's it. Lordship,
Yes, sir.
my genuine endeavor to actually convince your Lordship, if I can humbly submit before your Lordship that my name in the year 1966, my father's name is there, father's name is the son of so and so. If that is actually on record that I am the son of so and so in the year 1966 voter list, then what will be my fate, Lordship? Whether actually there is still actually doubt that in the mind of forest elements, border police and all that, I belong to, I am the entered actually illegally entered. In the voter list of 1966, my father's name, I'm the son of so and so. Page 54. Saitullah. That's all for the, that is getting. Number three? Yes? Hmm. नाम क्या होना है? Hmm. मतलब for the list? Yes. And similarly at page 50, Lordship may kindly be perused actually this annex at 10, where Rohimuddin, the son of Saitullah,
Page number?
page number 50.
Yes.
That is actually 421 to 51. Rohimuddin, name of the voter, son of Saitullah. Akbara Begum, wife of Rohimuddin, and so on. So. You can give me one, no? Give me one. This is one of the exhibited document, voter list of 2014. Huh? 66. 66. Page 56. 66. 66, Lord, Your Honor. Page 66. Total is 97. Similarly, page 70. 2010. Yeah, 2010. Here is Saitullah, son of Saharali. Rohimuddin versus Saitullah. Son of Saitullah. Saitullah, son of 70. 70. 72 annex 21 also may kindly be used. Rohimuddin Saitullah, son of Saitullah.
Mr. Uda, which is the first voters list where the name of the petitioner appears? First voters list
Page 66.
where the
Page
name
six-
of the petitioner
Page
appears?
66.
66. What you're showing is very sad. Is lack of reading the yes, Mr. Sharma.
Lordship, I have seen the evidence, Lordship. And Lordship has already pointed out, Lordship. I cannot tell the date of my birth. I do not know the age of my father as recorded in the voter list of 1966. I do not remember the year of date of birth, year of death of my father. He expired about 5 years ago. There is a
Just a
yes,
moment.
Lord. And Lordship, one Lordship, Sarbananda Sunwal, one case says Lordship, para 26, Lordship. There is a good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of India of a particular country. In order to establish one's citizenship, normally he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth and citizenship. Sometimes place of birth of his grandparents may also be relevant, like under section 6A 1D of the Citizenship Act. All these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence on rebuttal if necessary.
if the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. This is in accordance with the underlying policy of Section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving the fact is upon him. Then, Lordship, these are vital things, Lordship, to prove one's citizenship. Normally, he has to So, Lordship, all these things, Lordship, he has to place before the concerned tribunal at the first instance, that is during the filing of written statement, Lordship. And these are settled law, Lordship. And Lordship, beyond the things, the proceeding cannot go, Lordship. And Lordship, if Lordship, I have gone through the WS, Lordship. WS is totally fake, Lordship. WS is totally fake, Lordship. Nothing has been mentioned, Lordship. And Lordship, regarding WS, Lordship, Lordship, or High Court has settled the position, Lordship, in Rosminara Begum versus Union of India, 2017 4 GLT 346, Lordship. Retains that 2017 4 GLT 346. Rosminara Begum versus Union of India, RASHMINARA, 346, 2017 4 GLT 346. Para 25, Lordship. Written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal, keeping in mind the mandate of Section 9 of the Foreigners Act 1946. It is incumbent upon the prosecutor to disclose at the first instance itself, that is, in his written statement, all relevant facts ex- proceeding has exhibited only 8 documents, Lordship, and 1970 voter list, 1966 voter list, then Lordship 2014 Lordship, and 2014 his proceeding was initiated, Lordship, against the proceeding, Lordship. And so 1970 to 2014, Lordship, there is nothing, Lordship. All so there is a lack of continuous stay of the proceeding, Lordship. All the exhibited documents are clearly discussed in the opinion, Lordship. Yeah. There is no infirmity in the opinion passed by the learned tribunal, Lordship. So, Lordship, opinion may not be disturbed, Lordship.
Anything in reply, Mr. Huda?
Lordship,
Anything in reply you want to say?
Lordship. Page 77 in this actually petition, Lordship, where Lordship will find that names of voter list, relevant entries in the voter list, 77 have not been proved from the original electoral roll and by examining the officials who has issued the certified copy. But this is actually not required that certified secondary evidence is enough in the eye of the apex court, Lordship. In view of the judgment and order, yes. Yeah, in this the above contention, Lordship, this civil procedure code 1900 below certified copy of the sale deed is admissible as evidence for the purpose of proving contents of original documents. Facts of the certified copies of the directed against judgment and passed by the yes. No.
Yes. Yes.
That's it. No. No. No, it's certified copy that has been actually on record. That may be considered okay. Not that persons of appearing and the otherwise actually it is not accepted. The comment the version that has been in record. Lordship may consider the aspect that secondary copies of the voter list that is admissible in evidence. In Supreme Court, it is actually admitted. In other cases, in the lens method.
during continuation of the proceeding, some list has been placed, Lordship. But regarding that, tribunal has explained that Lordship, during continuation of the proceeding, proceeding on 12/7/2018 file a list of documents which has been perused. The documents enclosed with the list are certified copies of voter list of 1975, 85, 97, 2005, 2010, 2018, and one copy of NRC details and certified copy of the Jamabandi. But the said documents have not been marked as exhibit by the proceeding, and the documents have not been endorsed by me. As the documents have not been marked as exhibit and have not been endorsed by me, the aforesaid documents cannot be accepted. And mere production of voter list is also not enough, Lordship. Regarding that, Lordship, Aziz Mia settled the position, Lordship. Aziz Mia's case.
So Huda will reserve the judgment.
Lordship, my learned friend actually rightly contradicting that 78 page paragraph he has shown that during the continuation of the proceedings and proceedings so and so he has said the documents enclosed with the list of certified copies of so and so 75, 85, 77, so and so, where my name, my father's name, everything appears on this is a certified copy. As regards certified copy, what is the actually appends courts judgment in other cases, whether certified copies are admissible? Here, learned tribunal, they have said that the certified copy, objectionable or this cannot be tested, cannot be taken into account. But in view of the, so here, the Lordship to resolve this, that resolve in favor of Mike actually, the petitioner Lordship. This is actually a tragedy, a person, his family and their family members are not actually linked up with this case. Everything happening, all this state. So a man need to suffer. Justice of peace, Lordship, I am just before your Lordship about this. I may be actually, let me examine tribunal again on this point about the certificate copies issue, Lordship. If it is, I actually produce that he may exhibit, and then if I am actually adduce evidence also, then I will see that aspect also how much feasible for me, and as regards certificate copy also. Lordship.
Heard. Mr. Sudhar and counsel for the petitioner and so for the respondents. So the arguments are, arguments is concluded, judgment reserved. Judgment is order reserved. Yes, continue post lunch. We may be 5 minutes late in assembling again.
Yes, sir.
Item 12 for admission.
Non-appearance call for the petitioner. All the respondents are presented. Next para. By order dated 17/9/2025, this court directed that the registry shall reflect the name of the learned counsel for the petitioners whose name appears in the Wakalatnama, which is available in the records of MC 27/2025. While listing the matter next para. In MC 27/2025, for the advocates on record are Mr. Z. Ahmed, learned counsel for the Z. Ahmed, and Ms. R. Das. No. It will be Mr. E. Ahmed, E. Mustap Ahmed, and Mr. Z. Ahmed, Hamad. Just give us scroll for Z. Ahmad, Hamad. Next paragraph is order be brought to the notice of the AOJ FT section. Next paragraph is the matter on. Just keep it pending for some time. We are calling for him. Sir Ahmed, prepare for the-
Item 14.
No presentation from the petitioner. All the respondents are represented. For age of justice, the matter stands adjourned today. Next, part, it is made clear that if the petitioner remains absent on the next date of listing, he was orders. Next, part, list again on 31/10/2025. May I please ask?
So I'm sorry, my lord. My lord, what happened, my lord, in this case, I have already handed over the brief, my lord, to the petitioners. I think, my lord, some other two advocates have been appeared in this case, my lord. 14. A. Alam and J. Ahmed. Lord, I think A. Ahmed, Mr. A. Ahmed and Mr. J. Ahmed, think they have entered appearance, my lord. I have already handed over the brief, my lord. A long back, my lord, I have after hearing was completed, my lord, before the honorable court, Justice M.R. Pathak, my lord.
No, but we don't know this.
I pray, my lord, my name and my lord, S.S. Sikdar, S. Sikdar name may be deleted from the court list.
Supplementary file to them. Was in police custody and injury was there.
Your Lordship,
Injury is there in the postmortem report. Look at the postmortem report. You will find
My lord.
injuries are there.
But he was taken to police station in a drunken state, my lord. But if Lordship kindly allows me to, Lordship,
But then where is his production before the nearest magistrate?
no, at night, my lord, at around 8:30 p.m., he was found lying on a road. He was taken to police station, and in the morning at 6 a.m., wife came up with some foodstuff, and he was given. After that, my lord, he fell ill. He was taken to hospital, and ultimately, my lord, when he was taken to the BP Cholia, my lord, the hospital, he was declared dead.
Where is this? You see, he was a general diary entry was made, and you say that he was taken to Badradava MPHC.
Yes.
Examination by 9:30 p.m.
Yes, my lord.
Correct.
Yes.
Now, where is that?
Well, there is a injury report. The Lordship is indicating that, my lord, in the affidavit.
No, your affidavit ends at page 38. I think it is page 40. We have two numbers here. Kindly see page 40 of your affidavit. There are two numbers here. It may be wrong. It's a report from the Superintendent of Police, Nagaon.
My lord.
Second paragraph, you will read in the last part. He was in an in intoxicated condition on receipt of information. GD entry by so and so was made. But PS staff asked PO at Brahmapuri village. Duty person took him to so and so for examination by 9:30 p.m. After medical examination, brought to Badara PS. Now, if you've gone to the MPSC, there must be something to show that he has been taken there.
There has to be, my lord. There has
But
to be. my
you
lord.
see, you'll find here page 42 and 43 is that injury report.
Yes, my lord.
Not found any external injury.
bruise are there.
No, page 43. Patient was alcoholic, not found any external injury,
Yes.
but in the postmortem there is an injury. How do you account for it?
Well, in fact, in the postmortem report also, Lordship, these are bruised, Malad.
Do you understand?
Lordship,
Lordship,
Lordship.
But you see, before
There's
that, you don't have an injury. Page 43 doesn't have an injury.
But I have to get the GD report, GD entry and the inquest if any, Malad. I have to get that. Here, Malad, in fact, the matter was taken up earlier with the Shomoto PIL, Malad. Shomoto PIL was there. And in the Shomoto PIL, Malad, there is an order, Malad. In fact, after that, Malad, the Shomoto PIL has been closed and this matter remained, Malad. There is an order on 16/8/2024. Passing that that order is available here, Malad.
Additional affidavit, the respondent number 5 is relevant for the purpose. It orders the affidavit which filed on their placed along with this petition laid before the appropriate bench. So this matter is still open.
This is open. This is as regard compensation and the compensation claim for compensation and registration of case against the respondent number 4, 5, 6, 7, and 8.
So you see the inquest was not done and there is a, in the postmortem report, there is a injury report.
Well,
So your case for granting of compensation is made very strong.
So in fact, there is
Well,
very contradictory
no,
statements
I'll
made by
not-
themselves.
Just
in
a
the-
moment.
I'll not say well, that inquest was not done because he was brought to the PHE first, then he was taken to the hospital, the BP Cholia Civil Hospital. Possibly this is done, Malad, or not on record. I'll get that. Otherwise, this is a very important formality, Malad. They will definitely do that. I'll get that.
And because you see, Mr. Nath,
Malad.
today we may have one question, tomorrow we may have another.
No.
But
Whatever
everybody we can't allow you time to
record,
file
Malad, I'll get that.
For your lordship,
After-
information,
after-
there are 2 deaths in this case for Botodo
Two deaths.
incident. Another case is still to be filed by the petitioners. They are in a trauma, your lordship. They are on the roadside. They've been boycotted by the villagers. This lady after the incident, she's virtually begging, your lordship. For minor kids, everyone is boycotted them out of fear of the police, your lordship. We are
Why?
before your lordship. And
but
and
boycott is something
her
which have
husband
to-
was brutally beaten to death before her own eyes. She is the only witness, your lordship.
Boycott
10,000
is
rupees
something-
in cash was not given to her, to the officer in charge. Then he instructed his policeman to beat Sofiqul, and he was beaten to death before the petitioner's eyes, your lordship. That is the case. And they have fabricated this affidavit, they have contradicted by
No,
they're contradicting
this
themselves. your lordship.
arises, we are conscious of the fact, you see, this arises because of the burning down of the that Batterdeva police station.
Yes, your
That is the predicate offense.
No, if Lordship may allow me to please, Malad. But in the previous night, he was taken to police station. He died in the morning. Then, Malad, during the daytime, the police station was burnt down. And
What
in
will
fact,
be-
the petitioner was one of the person who was there, Malad, while setting aside the
No.
setting the police station at fire. She was also there. In the affidavit, Malad, we have said.
The
That issue, Lordship has already taken care, my lord, in the PIL, it was taken care of, my lord, and ultimately, we have also stated our
No, it's
reasons.
okay, this is only relates to the death.
Lordship.
Present PR is only related to the.
Yes,
death.
yes, my lord.
No further inquiry, but this. But this issue,
But I'll get the entire record, including GD and whatever they have, my lord, I'll get that, my lord. My lord, in fact, my lordship permits me, my lord, this matter has come up after a gap, my lord.
no, whatever we.
Lordship. I
Once
give
in the
me
case of
some
death,
time,
we
my lord,
have to take it up seriously.
Yes, absolutely, my lord. Absolutely, my lord. I'll get the record, my lord. Kindly give me some time, my lord, I'll get the entire record, my lord, whatever is available with them. We filed the affidavit long back, my lord, in the PIL, my lord.
No, then we understand, but since it's a case of death, we have to.
Correct.
see
In fact,
everything.
petitioner also did not insist that, my lord, this has come after a long time, my lord.
No, that's okay. We are not on that.
Lordship.
Once it's a case of death, it's the responsibility of the court to look into it.
Lordship. And my lord, their house, it got damaged, and for that, my lord, compensation was paid. It was already paid, my lord.
Payment record, we did not find anywhere.
My lord, in fact, my friend is there, my lord. He cannot
No,
deny.
there is some reference somewhere, I forgot where, I read it. With regard to the bulldozing of the house. For that you have paid some some compensation for
Yes.
which there was some delay in the
Yes.
sanctioning.
Yes,
Some document I have found some.
in the PIL, that those orders are available in the
It's
PIL.
here also,
Lordship.
but I won't be able to immediately tell you what. Tell you
Sanction?
where, but there's something on record with
Well,
that.
in fact, I have the sanction order, my lord, 12th of June, 2024.
It's not regard payment of compensation to the petitioner.
Payment of compensation to the petitioner, my lord, for demolition of his house. Demolition of house.
Not
Yes.
to the death.
Payment could not be given because the next of kin certificate petitioner was unable to produce that. That is why there was some delay, but by this time possibly he has gone.
Yes, sir, we have received that
He has-
amount. Your
he has received.
bulldozing,
He has
we
received.
have received that amount. Your
Yes.
We are not on that. That's not the scope of the PL
My lord,
right now.
Lordship. For the other records, kindly give us some time, my lord. I'll get the entire records, my lord. If the lordship has asked for the in-case report and the,
3110. You will have
my lord, 31.
sufficient time.
Yes, my lord.
Kashi. বহুত কাগজ আছে চিৰিয়েল কৰি পেলাই বেলেগ এটা কৰি দিব নকৰি আছে contents of annexure to the additional affidavit filed by the respondent of 5 on 9/8/2024 that on 25/2022 on Safiqul Islam, SAFIQUL Islam, was taken to the Batadawa, BATADRAVA, Batadawa, MPHC for examination by 9:30 PM of 25/2022. However, the medical, the medical report discloses that the patient was alcoholic. However, it is further stated that no external injury was found. However, on a perusal of the contents of the postmortem report, which is annexed to the said affidavit, description of two injuries are reflected therein. Accordingly, the learned senior government advocate pays for some time to produce the relevant records. Next para accordingly lists the matter on 31/10/2025.
Item 17.
May I please, your lordship?
Yes, Mr. Dev.
My lord, in this case, a record was called for, my lord, record has received, my lord. And my lord,
Absolutely. Yes. Yes.
my lord, in this case, my lord, actually reference was made to determine whether petitioner is a foreigner, petitioner wears foreigners within the period 66 to 71 or not, my lord. That was the period. And actually, petitioners are declared foreigner within the stream, my lord. But my lord, in the judgment, there is a mistake, my lord, committed by the learned member. Instead of Sochindra Chandra Das, it was typed as Heru Das and others. This is one of the reasons, my lord, the petitioner could not register their names. And moreover, my lord, the petitioner's father died long back, and the petition number 1 and 2 was minor at that time. They were not aware of about the judgment, my lord. Subsequently, when they came to know, that is also long back, my lord. And there is delay in approaching this honorable court, my lord. Humble prayer, my lord. A direction may be given to the learned members to correct the judgment, the name of the petitioners, and their name may be, direction may be given to register their names. My lord. My lord, the name is typed as Kherodas. My lord, kindly see page 30. Huh? Page 30, my lord, annexer P8. The certified copy, my lord, here it is written, my lord, State of Assam versus Shoshindra Kumar Das. But my lord, in the next page, 31, the judgment, it is written, my lord, State of Assam complainant versus Kherodas and 4 others. So Kherodas is not in this case, my lord. It ought to have been, my lord, the Shoshindra Chandra Das. My lord.
That he was prejudiced by this non-inclusion of the correct name in the opinion.
But my lord, when petitioners approached before the SP, Diffu, my lord, they refused to register their names
No,
as.
because you are not the process, you're not the person against whom the process was made. The proceedings was not against you.
Page 24. Page 24. Page 24. Page 25. This is the free copy given. Kherodas is the link to this petition. Shoshindra Kumar Das, last paragraph. It's not the party. That is the mistake. 88 order. Same.
You see, Mr. Dey,
My lord.
look at the back page of the last page.
Last page, my lord. Last paragraph.
No, not your last page. Like last page of the record. Back page of the last page.
This is the following document. Evidence certificate number 67. DC. DC. Number 5.
Last is copy of judgment and your father received it and signed it. So your father had this document. The tribunal served him a copy of the judgment.
The copy, that free copy I have annexed, my lord.
We understand, but
My lord.
what we are trying to understand from you is, how can your father never complained of any prejudice just because there is a typing error in the order?
My lord.
Tribunal gave him the copy, but he did not register. Once that is not done,
That is not.
then you will be hit by the recent judgment of the Supreme Court, which says that in citizenship, once steps are not taken, then the time cannot be extended. You are hit by that judgment of the full bench of Supreme Court in connection with the 6A of the Citizenship Act. It's a very clear-cut observation. And you are not the proceedee, so you can't go and register it. So it is only when there is a proceeding against you, then perhaps you can take a defense.
My lord, during the lifetime of the Prasendra Chandra Das, my lord. Perhaps, my lord, I have information that he, as direction, specific direction was not there, but he does not know about the registration. My lord.
But he's given a copy. That's why we saw that record.
And the others members, my lord, at that time was the minor, my lord, they are
That's
not
what
aware of
recording-
the judgment. And moreover, my lord, another submission, my lord, under the Amendment Act of foreigners, that is foreigners orders on 1948, my lord, it's amended. That also, my lord,
No,
it
now
is-
that is also gone.
specifically, my lord,
Now that is also gone. Now we have Immigration and Foreigners Act. New act has come now.
Yeah.
2025. And the orders have also been amended. And it has been substituted, in fact. The New act, where is that? This new act which has come. Immigration Act.
16 and 19.
New Immigration and Foreigners Act. I thought.
My lord, I am referring, my lord, foreigners order 1948,
No,
order
this-
3 capital A.
No, you see now. This. All this has been. With the new act. All this has been taken over by the Immigration and Foreigners Order 2025. You are referring to Foreigners Order 1948.
48. Exemption, my lord. Order 3 capital A, exemption of certain class of foreigners.
You don't know, look at this. It's page 40 at the top. Read from the top in supersession of.
Immigration and Foreigners Order 2025. In exercise of the powers conferred by Section 7, read with Section 3 and 11 of the Immigration and Foreigners Act 2025, and in supersession of the Foreigners Order 1948, the Foreigners Protected Areas Order 1958, the Foreigners Restricted Areas Order 1963, and the Foreigners Tribunals Order 1964, except as respect things done or omitted to be done before such supersession,
No,
the
those are not
central
important.
government hereby makes the
Others are not
following.
important, but the fact remains that 48 has been superseded.
My lord, 48,
Superseded.
superseded. I pay some time to go through this, my lord. Sometime may be allowed to check the law, my lord.
Because you see, Mr. Dey,
My lord,
what we understand is that you are not the aggrieved person.
my lord,
With that order, your father was the aggrieved person.
my lord,
You may know about it, you may not know about the order.
my lord.
But the fact remains that as per the tribunal's record, it was served on your father. He received it. And whether he registered himself or not, we don't know. Because that is something which is within the domain of the FRRO, Foreigners Registration. And if it is not registered, then I would forget the paragraph. You will find it in the what do you call 6A of the Citizenship Act.
My lord.
In that judgment, it says that once there's a direction to register and not registered, then that would lapse.
My lord.
So therefore, it can't be registered now. That's one. Second is that the only consequences we conceive of is that if there is a proceeding drawn up against you, then you can take this as a defense. That your father was referred to as a foreigner. You have seen perhaps the record. The SV's reference is 1967 you entered into India. As per the records,
Yes.
it is the reference is that Superintendent of Police says that you entered into the country in 1967.
Well.
So therefore, that can only be your defense.
Hmm.
But you adjourn it, you find it out. What says the represented? Prayer made by learned counsel for the petitioner. Matters since adjourned today, placed on 31/10/2025.
No problem.
Nineteen.
May I please your lordship? Ex parte, my lord. My lord, what happens in this case? Lordship may kindly see relevant paragraph is at my lord 41 about ex parte here.
Page
Page 41, my lord.
41.
41, my lord. It is part of my opinion, my lord. Accordingly, after registration of the case starts.
Notice is duly served. It says pasted in the office of the Gaungura.
My lord. But it could not be served to the petitioner, my lord. One more submission is there, my lord. This case was against Musannat Moorjan Nessa,
Yes.
wife of Muhammad Nur Muhammad, village Satta. And my lord, present petitioner is Moiri Begum. But police is against her, my lord. And he is
That you have to
presently
satisfy with the
residing at,
tribunal,
my lord.
because in most of the cases you say that it's very common to have alias. Every day we hear only that argument. It's very common to have alias.
She is a resident of, my lord, Sengalidia village.
No, but there is something somewhere I read that you've been changing your residence frequently. What are the documents you are having?
My lord, I have annexed all the documents, my lord, right from his school
Anything
certificate.
Connect you to your projected father?
Projected father is, my lord, Ghani Ali. Which you may kindly see. First, annexure 1 is, my lord, her school certificate issued by the Lokopriya Bodle High School, Jajikona. That is her school certificate, my lord. Read up to class 9.
Just
The father's name is Muhammad Ghani Ali.
Where is your name in the first voters list? In which voters list your name appeared first?
I have annexed only, my lord. Achievement kindly see of, along with my husband. That is, my lord, at page 34. Page 34, my lord, along with my husband. Sangalidia village, my lord. First, along with my husband, my lord. I have annexed, my lord.
Age is 26.
My lord, age is 26.
Until 5. That's it. 2010. So, yeah, good one. Okay. Yes, Mr. Sharma.
Lordship.
He's the
Husband name is same, Lordship.
husband name is same, father's name is almost same.
Yes, Lordship.
Gani Mia and Gani Ali.
Yes,
Inquiry was made in 2005. In 2009, the name changes.
name changes, yes, Lordship.
My lord.
But
And Gowra has deposed that without intimation to the
Left.
concerned police
this is
station.
something you'll have to see.
My lord, in a similar, my lord, coordinate bench judgment, I have procured, my lord.
Now look,
Directed.
in the right side page. No. Sorry, left side page. You see the last few lines.
Last two line.
Read the last few lines.
এতিয়া মই অত্ৰ থানাত
Ah,
উক্ত IMDT কেছটোৰ মোকৰ্দমা পঞ্জী বন্ধ কৰিলো আৰু সন্দেহী মোছাম্মদ মৌজান নেছাৰ নাগৰিকত্বৰ সুবিচাৰ কামনা কৰি মহামান্য IMDT আদালতলৈ বৰপেটা জিলাৰ
now look at right hand side, first line.
I think that right.
statement of
Oh, last line, last.
Statement of,
নয়নতৰা নেছা
where is, who is she?
Village
yes,
Satta.
Lordship.
Who is she?
নয়নতৰা নেছা statement of a suspect মোহাম্মদ নয়নতৰা নেছা
Who is she? And you will see left hand handwriting is different, right hand handwriting is different.
Lordship.
You have to remind it, you can't do anything. Your defense, whatever is there,
Yes, Lord.
you are the suspect.
Yes.
Only thing is to be ascertained. Moirjan Nessa, Noyantara Nessa, and my lord, Moiri Begum.
If you want our opinion, we can give it. But you don't want to.
Lordship may kindly remind.
Because that's why we asked you the voters list. Your age tallies with the voters list. That's why.
Yes, my lord.
When your statement
Continue.
was taken, you were 20, in the voters list, you are 26, voters list matches. So after this inquiry, you left. And that is when you are not in this village. You have shifted to another village.
Yes.
Your voters list is only thereafter. Post inquiry, that is your first voters list. Heard Mr. J. Sharma and counsel for the petitioner and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, or the petitioner, namely so-and-so, has assailed the impugn opinion, ex parte opinion dated set page 40,
14/6/2020, Chairman.
14/6/2023, passed by so-and-so and so-and-so. They were declaring the petition to be a foreigner post 25 to 1971 stream. No, don't say that. Pardon? Pardon? As a post 25th century, as the petitioner remained absent and failed to discharge a burden of proof as provided under Section 9 of the Foreigners Act, 1946. Next para.
No.
The learned counsel for the petitioner has submitted that the notice was not served in accordance with the mandate of section of order. Three 5G of the foreigners within bracket tribunals, bracket was order, 1964. Next per contract, the learned standing counsel for the FT matters has submitted that the records revealed that after the police inquiry was made, the petitioner had changed the name and the address, and therefore he submits that the impugn opinion does not call for any interference of this court. Next para. On a perusal of the tribunal's records, it appears that the address of the petitioner, as provided in the notice, would not be, sorry, the petitioner should not be located in the address provided in the notice. Which is also reflected in in paragraph 3 of the impugn opinion. So as per the process service report, on on being unable to find the petitioner, the notice was pasted in the notice board of the Gambura. Full stop. There's a certificate dated 27/3/2023 issued by the Gaon Pradhan of Village Chata, CHATA, charge number 20, disclosing that no such person resides in Chata village. Next para. Furthermore, having regard to the mandate of Order 3 within bracket 5 within bracket G of the foreigners within bracket travelers bracket close Order 1964, which requires a copy of the notice to be pasted in conspicuous place of the last residence, same having not been done, is found to vitiate the manner in which notice is served, which also vitiates the ex parte opinion dated so and so impugned in this writ petition. Next, accordingly, the impugned opinion dated so and so, page 30, page 40, past tense so is hereby set aside. Next, resultantly, the matter is remanded back to the learned member, Partners Tribunal 7, Porpeta, for a fresh adjudication of the matter. Next para, the petitioner, who is duly represented by a learned counsel, is directed to appear before the learned member, Partners Tribunal 7th, Porpeta, within the outer time limit of 24/11/2025, and by producing a certified copy of the order, await for further instructions from further orders of the instructions from the said learned tribunal. First of on appearance, the petitioner shall also file a written statement of defense and also file any document on which he intends to rely upon. Next para, in the event the petitioner remains absent within the time allowed, absent before the tribunal, or does not appear within the time allowed, it would be open to the learned tribunal to treat the petitioner as absent on call and pass a fresh opinion in accordance with law. Next para, the registry shall send back the records of the tribunal expeditiously. So that we said that we've had a written statement of defense. After that, you say, so thereafter, the learned tribunal shall give sufficient time to the petitioner to submit her evidence and to produce witnesses in support of her defense. That's all. The writ petition stands allowed to the extent as indicated above, leaving the parties to bear their own cost.
Obliged, heard.
Item 20.
May I please, your lordship, I am paying for examination this matter for today. Pass over this matter. also.
Yes, I think. Okay, both sides are represented. On the prayer made by non-counsel of the petitioner, the matter stands at hearing today. List on 31-10-2025. 31-10, no adjournment on that day.
Obliged.
Other matters will have to be adjourned because we'll have to rise for the single bench. If there's any urgency in the matter, please tell the court master, we'll have to make some adjustments.
Lordship, item number 22, last 4 occasions, Lordship.
We can't help it.
But he's not on interim. She.
Yes. Tell the court master, after I rise, tell the court master will get it. So this is something we'll have to start living, start learning to live with. We can only work to the maximum possible. We can give maximum possible effort, but we can't do anything more. Yes. That's great.
Item 1 with 2.
You appear for all the respondents?
Yes.
Is this IA? 1308. This has a prayer for extending the period of service of notice. Since you have appeared, we close this matter. This IA is not a live issue.
We have not received any of the IA law, the copy of the IA or the review petition.
You have not received. You have not received.
No, no. You can kindly give it directly.
None appears on call for the applicant. However, Mr. I, Ahmed, learned counsel enters appearance for respondent numbers 1, 2, and 3. Only 3 respondents?
All the three.
Okay. And submits that as the notice was served in a substituted manner, the respondents have not been served with copy of the interlocutory application or the review petition.
All the.
Okay, any interlocutory applications as well as review application. Next para. In this interlocutory application, the period is limited to extension of time for making newspaper publication of notice, upon appearance of the respondents, the matter has become infructuous. Accordingly, this interlocutory application stands closed, having been rendered infructuous. Now, in this 868, you see none appears on call for the applicant. However, Mr. I, Ahmed, and counsel appears for respondent numbers 1, 2, and 3. It's submits that he has that the respondents have not been served with the copy of this interlocutory this interlocutory application as well as the connected review petition. Or you say any interlocutory application or the connected review application. Expert, the applicant, the learned counsel for the applicants is directed to serve copy of all interlocutory applications as well as the copy of the connected review application to the learned counsel for the respondent numbers 1, 2, and 3. Next paragraph. List again on. Please take the date after some time because we have a single by someday he'll find out and then give a date on that day. Please wait for some time. Just wait, he'll check up and give you the date. Give you a date too. There's no other matter? Okay. Start.
Malun. 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 By tomorrow, I'll give mine. I have got his number.
But